Ladies and gentlemen, welcome to IR Law webinar. My name is Vishnu. I'm one of the consultants for IR Law. Thank you very much for attending today's webinar session. This is our August webinar session. We've had several within this year, and we will have several more by the end of this year. We hope you continue to attend and join our sessions and enjoy what we have to offer. Okay, to introduce myself, my name is Raja Vishnu. I'm one of the consultants for IR Law. For those of you who are not familiar, IR Law is a industrial relations consultancy firm, and we provide industrial relations and HR related advisory as well as consultation to all our members. We also assist our members in legal representation, industrial court, as well as in labor department, and etc. Okay, so moving on, today's session is headed by our speaker, our invited guest speaker, Mr. Donovan Cheah, who happens to be our partner in Donovan and Ho. And what he is going to be talking about today is on probation, extension, and termination. A very, very interesting topics. We hope to have all your questions. You get ready with your questions by the end of the session. Before the end of the session, Mr. Donovan will try to reply to all of your queries. So to properly introduce Mr. Donovan, Mr. Donovan actually leads the firm's employment law and dispute resolution practice. His work in the profession has been recognized by publications such as Legal 500, Chambers and Partners, Asia Law, and Benchmark Litigation. The Legal 500 Asia Pacific has named him as a recommended lawyer for labor and employment in their 2017, 2018, 2019, and 2020 rankings, whereby he is described as understanding, efficient, and direct, and the name to know. Donovan is also a registered foreign lawyer with the Singapore International Commercial Court. He is a fellow at the Singapore Institute of Arbitrators and the Malaysian Institute of Arbitrators. He sits on the Malaysian Bar Industrial and Employment Law Committee as well. Okay, without further ado, I will present to this webinar section Mr. Donovan. Thank you very much.
Thanks a lot, Raja, for the introduction. If you give me just a moment, I will share my screen for the slides. Okay, good afternoon, everyone. This afternoon, I will be having a short discussion or a short presentation about managing and handling probationers. The way I'm going to do this session is a little bit different rather than just having a webinar where I talk completely about the law and cases. I'm going to split this webinar into two main portions. The first portion, I will address it in the form of frequently asked questions about probationers. And towards the end, I will do a case study, selected case studies from 3 industrial court decisions that were delivered in 2021. So this would be 3 latest decisions from the industrial court relating to the issue of probationers. Right. So before we start, I think all of you here would know what is a probationer, but just for good measure, a probationer is an employee who is undergoing a trial period before they get confirmed into their role. So those of you in HR would be quite familiar with this concept. It is a situation where you have a new joiner. Typically in the employment contract, it will provide for a probationary period. The probation period can range anywhere between 1 month to 6 months or longer. And it is during this period where it is something like the employer and the employee getting to know each other. It is an opportunity for the employer to assess whether this person is suitable, capable for the long run, and whether this person is appropriate to be a part of their workforce in the future. So that is what the probation period is for. Sometimes you will see a probation period not just for new joiners in a company. Sometimes you will also see a situation where someone who is an existing employee being elevated to a new role or maybe being redesignated to a new role, and they will be put on a probation period as well, because sometimes the capabilities or the competencies required for the new role or for the promotion may be a little bit different from what the employee was previously doing, and the employer may want to assess whether this person is suitable for that new role. So you can see a probation in two aspects, for completely new joiners, fresh joiners, and also for those who may be taking up new roles in the same company. So what is the main difference between a probationer and a confirmed employee? Now, a probationer is the category of employee I mentioned earlier, but a confirmed employee is someone who passes their probationary period, if there's one, and they are confirmed in their employment. Okay, so the main difference, I would say, actually relates to the remedies that are available to them at law in the event of a dismissal. In a typical day-to-day work, I wouldn't say there is much difference between a probationer and a confirmed employee. A probationer is still an employee, if there's any doubt about that. So they still have employment rights if they are, for example, covered by the Employment Act 1955. So if there is a person who is earning less than 2,000 ringgit or engaged in manual labor and they are on probation, they are still entitled to certain rights under the Employment Act, even though they are not confirmed yet. So what's important to note is that the Employment Act, for example, doesn't distinguish or doesn't define probationer as a separate category of employees. So for all intents and purposes, a probationer is still an employee if they're under a contract of service, and they do have certain statutory rights if they are applicable to the Employment Act. All right, so the main difference you would see for a probationer and a confirmed employee really lies in the remedies that they have when the probationer is dismissed. So in the Industrial Relations Act, particularly the second schedule of the IRA, this covers the remedies that are available to employees when they are unfairly dismissed. If you can look at the first paragraph here on the screen, where an confirmed employee has been unfairly dismissed or decided to have been dismissed without just cause and excuse, the maximum back wages that they are entitled to is up to 24 months from date of dismissal based on last drawn salary. Okay, but in the case of a probationer, if you look at paragraph 2, so this is where the word probationer is specifically used in the statute. If it's a probationer and they are dismissed without just cause and excuse, the back wages cap is limited to 12 months. So half of what a confirmed employee is entitled to. So this, I would say, is the main difference in respect of the remedies available between a probationer and a confirmed employee. Of course, a probationer is undergoing a trial period. So as we will cover later in the FAQ, the company is allowed to assess things like character, aptitude, and other factors in assessing whether the probationer is confirmed. And there is case law which does say that while a probationer is an employee, they do not have a lien on the job. So they are not guaranteed confirmation. They are still required to undergo this trial period and let the employer assess whether they are suitable to be confirmed. So those are the major differences between a probationer and a confirmed employee. So is there a special legal test for dismissing probationers, or we use the word non-confirmation, all right? Because when you, at the end of the probationary period, when you tell the employee you are not confirming them, you essentially mean you're dismissing them because they will no longer be part of the organization as well. So is there a special legal test for dismissing or not confirming probationers? The answer is no. There is no special test just for probationers. When a probationer is not confirmed, the similar test will apply to determine whether this person has been dismissed without just cause and excuse. There could be, of course, minor nuances when we deal with the circumstances or factors relating to a probationer, but the overall test remains the same. The question that the court has to ask themselves is whether this employee was dismissed without just cause and excuse, or whether there was a good reason for not confirming this employee. So similarly, like any other employee, you can't say that you dismiss the probationer for no reason, or that you do not want to confirm him for no reason. You must give a good reason, and the typical considerations that apply or have been accepted as good reasons are the three usual ones, which is poor performance, misconduct, and redundancy or retrenchment. All right. So now that we've covered just a basic overview about probationers, and we have the scene set, what I intend to do now is to cover some frequently asked questions about probationers. Okay, because in my practice, we have a lot of clients who are dealing with probationers, and we realize that there are quite a few questions which repeat and are frequently asked, and everyone seems to have the same type of questions relating to probationers. So I thought what would be helpful for the presentation today is for us to cover these questions that are commonly asked. So the very first question is, when you are drafting your employment agreement, or when you are offering a position to an employee, one of the questions we get asked is, what is the probation period that I should put inside my contract? Okay, should it be a minimum or maximum period, or do I have to put a fixed period? All right. So the easy answer is that under law, there is no fixed period under law that you need to put for your probation, for your probationers. It is really a commercial decision. Like I said, it is not even mandatory to put a probation period, although highly recommended for new joiners. So the company or the employer can decide whether they want to have a probationary period or not. And then what is the minimum or the maximum is really up to the company. So the factors that you consider in determining the probationary period normally will depend on the role of the employee. For higher ranking employees, or employees who are handling very, I would say, important responsibilities, there tends to be a longer probation period. Sometimes 3 to 6 months would be an example. Okay, I've seen up to 6 months as well, probation for high responsibility roles. For roles which are maybe, I would say, not so high in responsibility, lower level, more administrative, more run-of-the-mill types of jobs, we don't really see long probation periods. Normally, anywhere between 1 to 3 months would be quite common to assess this person's capabilities and suitability for the role. Okay, so again, under law, no minimum required, no maximum period required as well. Can the company extend the probation period, and is there a limit to the number of times? So we often see a situation where you have in your contract, let's say a 3-month probation period, and at the end of the 3 months, you discover either you need more time to assess the person, or you have assessed the person and they are not so good, but you would like to give them another opportunity. So the question that arises is whether you can extend the probationary period. We've also seen quite recently, due to COVID-19, the pandemic, some of you may have encountered the situation where you're not an essential service, and then there was a lockdown. A lot of people couldn't operate and couldn't come to work. So there were a lot of roles which physically could not be done from home. Okay, there would be some people who need to be on site to actually carry out their functions. And if they are on probation, then it becomes a question of, the company couldn't even operate for, let's say, 2 months, but the probation period is 3 months. How am I going to assess that person if they weren't even working during that period and they weren't on site? So can I extend the probationary period? The answer is yes. The company does have a discretion to extend the probationary period. And there is no law which specifies how many times you can extend. But what we always say is using a reasonable guideline. You shouldn't be extending probationary periods for unlimited number of times or for multiple occasions. Usually after 1 extension, or maybe at most 2, you would already be in a position to assess whether this person is suitable or not for you, unless there are very, very extenuating circumstances which prevent you from doing that. Okay, so one example I've seen was in the retail industry. So during the first MCO, all non-essential businesses closed. There were retail businesses who had employees who were, for example, boutique staff or boutique managers who actually really need to be physically present to do sales for the company. Okay, and these companies do not have online business, they don't do e-commerce. So really, when the company was ordered to close due to MCO, nothing is going on in that business, literally like zero business, zero revenue. So there were some employees who were on probation, and the probation period would expire during the MCO period. And the company there in that case would say that, sorry, I just don't have enough opportunity to assess you because of those situations. So I'm going to extend the probation to give me a better chance to evaluate your performance and whether you're suitable for the role. So in those cases, the company did extend the probationary period, and that's perfectly acceptable as well, okay, because of the surrounding circumstances. Can you dismiss a probationer before the end of their probation period? So this is another common question. Let's imagine a situation where you put in your employment agreement a probation period of 6 months, okay? And then after 2 months, you find this employee is just really problematic. You don't like this person, doesn't seem like a good fit, not doing their job, maybe very rude, very difficult, doesn't fit with the culture, and it's only 2 months in. And the question that we get as lawyers sometimes from a client is, do I have to wait for the balance 4 months to be over before I can get rid of this person? Because really, I can tell you in the first 2 months, I already know that this guy is not going to make it, cannot make it. All right. So am I bound by this probationary period and I have to like carry on suffering with this person just because I put a probation period for 6 months? So the answer to this is in a case which I've put here. This is a federal court decision, Casey Matthews and Kumpulan Guthrie, Sendirian Berhad, from the 1980s, but still applicable. In this case, if you can look at the underlying position, okay, this was a quotation that they referred to from another case, but it says that it is clear to us that without anything more, an appointment on probation for 6 months gives the employer no right to terminate the service of an employee before 6 months had expired, except on the ground of misconduct or other sufficient reasons. At the end of the 6 months, the employer can either confirm him or terminate his services if his performance is found unsatisfactory. So in this case, it involved a probationer who was appointed as a clerk for the employer. And throughout this probationary period, he wasn't doing his work well. And essentially, there was an issue about attitude, whether he had talent for the job, whether he had industry, or whether he was hardworking for that. So ultimately, he was dismissed. Here, the court upheld the dismissal because of him being a probationer and the employer having a right to assess that. But the takeaway here is the general principle which was pronounced is that if you provide for a probationary period of a fixed time, like 6 months, the general rule is that you should let the employee serve out that probation period, because that is, in a way, what you've represented to the employee, like how much opportunity you're going to give him to prove himself. So if you have already represented to the employee that I will give you 6 months to prove yourself and prove your work, general rule is that you should comply with that because that's in the contract. However, there is still an exception. It doesn't mean that you must keep the employee up to the end of the 6 months or whatever months, and you have no choice. The court has provided exceptions, and it would be basically ground of misconduct. For example, if during the 2nd or 3rd month, the employee steals money from you or commits fraud or corruption or gets into a fight, you are entitled to dismiss them immediately without having to wait for the end of the probation period. They've also put the word or other sufficient reasons, in which case even the services of a permanent employee could be terminated. So the court hasn't defined what is other sufficient reasons, but as with any other employment case, it will boil down to the principle of just cause and excuse as well. So if you are able to justify why you need to get rid of the employee or the probationer before the period is up, you would be able to have the opportunity to explain to the court, and they will assess whether that is just cause or excuse at that stage. But general principle applies if it's a performance issue, like you're not so comfortable with whether they're a good fit or not, you still have to run through the probation period because that's what it is there for. Now, should you do a performance review throughout the probation period or at the end? So this is a practical question because what we often see also as well in practice is that you put an employee on probation, let's say 3 months, and throughout these 3 months, the guy just does his job. Then at the end of the 3 months, the supervisor or the employer says, I don't think it's working out. I don't want to confirm him. Actually, he's not a good employee. So they only run through that evaluation at the end when it's time, they get a reminder from HR. Okay, like, oh, are you going to confirm this guy or not? Then only at the end of that period, they say, okay, yeah, actually, he's been quite bad. I had to lecture him a few times and, he's not a good fit. So this becomes an issue because when you decide not to confirm a person at the end of the probation, typically the employee will ask, why? What did I do wrong? And if you tell him that, oh, you just weren't up to task, you're not a good performer, the first response will normally be that, but you didn't tell me earlier, I've been with you for 3 months. I had no idea that I was performing badly. And if you told me earlier, I would have had a chance to maybe fix it, or I would have a chance to know your expectations and work to meet those expectations. So the question is, should you do it at the end of the probation period or should you do it throughout the probation? So good practice is always treat it like any other employee. Just because you're probationers doesn't mean you don't have to do performance review. You should always assess their performance throughout the probation period and take opportunities to run through or highlight shortcomings with them, especially if you feel like there's something serious which needs to be addressed. Don't wait until the end of the probation period when your HR asks you to tick that box, on the form, what's your recommendation, confirm or not confirm. Only then you start doing the evaluation. So you should be running through a performance review regularly. It doesn't have to be a formal one where you do like those performance evaluation form and all that, but do make sure that you are monitoring and engaging your probationers as well throughout this period. Change the slide. Okay. Should you do a PIP then for probationers? Let's say if during the probation period, you find out that your probationer is not great, okay? And if it were a permanent employee and you have performance issues, what HR would normally recommend is that you do a performance improvement plan or a PIP. So the question is, should you do that for your probationers, or do you not need to if they are on probation? So again, there is no specific rule, but because like I highlighted before, the test for dismissing probationer is the same as confirmed employees in the sense that you must show just cause and excuse. A PIP or performance improvement plan is one of the ways to meet the legal criteria for a poor performance termination. So there is, I would say, nothing preventing you from doing a PIP for probationers. In fact, it may be a good idea as well, because it will give you the opportunity to highlight and justify to the probationer things aren't going their way, and it's very likely going to end up with a non-confirmation if you keep it up at this performance rating. So PIP can be considered for probationers, not mandatory. If you don't want to do a formal PIP, you should still try to put in those criteria of a PIP, for example, communicating in writing to the probationer what is wrong, giving them the opportunity to improve. For example, you can say, look, you have 2 more months left on your probation. I expect you to use these 2 months to meet all your goals and your KPIs. And then thirdly, before you non-confirm them or not confirm them, make sure you have proof or evidence that they failed to improve despite you giving them all these warnings. So that's what a PIP does, but you don't have to do it in a PIP structure as well. It's perfectly fine to do it your own way, as long as you cover those legal criteria. Another question is, are probationers automatically confirmed? Okay, this sometimes happens or is a key issue in larger companies where you have multiple employees coming in on regular basis, and sometimes it is a challenge to keep track of when the probation period lapses. It could sometimes be a shortcoming either from the HR department or from the supervisors themselves who are not monitoring when the probation period is up, and they're not keeping track of the things that they need to do, for example, issuing the confirmation letter. So if you give a probationer an employment agreement and you say you're on probation for 3 months, and then everybody does their work, very busy period, 3 months pass, nobody says anything, 4 months pass, 5 months pass, 6 months pass, 7 months pass, then suddenly you realize that, oh, I forgot to confirm this guy, or actually this guy is like giving me problems, I should have not confirmed him, or I had a reason not to confirm him. Is at that 6 or 7 month, is that person still a probationer? Or can we treat it that because the probation period passed and you didn't say anything, you forgot to say anything, and you didn't raise any problems, this guy is treated as confirmed? Okay, the answer is, in that same case, which I mentioned earlier, Casey Matthews, it also covers that situation. It says that if you do not take any action at the end of the probation period, whether to confirm the person or terminate that person, the employee continues to be in service as a probationer. So in summary, no automatic confirmation. If at the end of the probation period, the employer doesn't take a positive step, for example, giving a letter of confirmation or giving a letter of non-confirmation, for the time being, the employee will remain a probationer. But what we normally recommend is that when you are drafting your employment agreements, you should kind of put that clause in the probation clause to be very clear that there's no automatic confirmation. This is to cover the situation where sometimes you may miss like 1 day or 2 days, or in very worst cases, you miss the probation period and by about 3 months, then you are stuck in this limbo where the employee may be confused whether they're probation or not, as the employee may not go and read this Casey Matthews case, correct? So to make it very clear, we normally recommend, if you're drafting the employment agreement, put that sentence in, like for the avoidance of doubt, there's no automatic confirmation at the expiry of your probation period. You are only deemed confirmed upon receiving a confirmation in writing. So that normally makes it clear to the employee as well that they can't, go, haha, like you've passed the probation period and you didn't exercise your right to not confirm me. Okay. However, there's also one exception. In this other case called Abdul case, Abdul Majid case, if you as an employer, after the probation period has expired, you don't say anything confirm or not confirm, but you continue to treat him as if he were a confirmed employee, it can be deemed that you have confirmed that person through conduct, even though there is no letter in writing. So an example would be, for example, if probationers are entitled to only, let's say, 10 days of annual leave, but confirmed employees would get extra 10 days, so they get 20 in total. And you have a probationer, you forgot to confirm him, you carry him on in employment, and then in HR, you update his benefits to say he's entitled to 20 days and he knows that and is in his leave balance 20 days. In such a situation, the court may form a view that you have by conduct confirmed him, because you wouldn't have increased his benefits if he weren't a confirmed employee. So again, be very mindful. We normally recommend to avoid these kind of situations, if you have different benefits for probationers and different benefits for confirmed employees, please be careful. Don't automatically update the benefits for them if there's no confirmation letter supporting that. All right, so this is more for HR operational perspective. Be careful about this. How about this? Can a fixed term employee be on probation? What is the legal impact? Okay, a fixed term employee is a contract. Fixed term employees are on a contract for a specific time period. You will see this, for example, like you're employed as a person in this position for 12 months only. And at the end of the 12 months, you may or may not be renewed, or the contract will lapse, and then that's it, you've done your job. So for this type of employees, can you put them on probation? The answer is yes. There is nothing to stop you from putting a probationary period in a fixed term contract as well. So you can have a situation where you employ this person, let's say as a project manager for a specific project for 12 months, and you say that, but the first 3 months of this, you're under probation. That's fine as well, but it has to be included in the contract and drafted clearly that it is a probationary period. So what is the legal impact? The legal impact of putting an employee on probation normally arises, the main difference will arise again when there is a dismissal of the employee on a fixed term contract. This is because, if you can see here, when an employee is dismissed, earlier on I showed you permanent employees get up to 24 months back wages, if they're confirmed. Probationer gets up to 12, which is half. But fixed term contract employees, their remedy is the balance of the unexpired term of the contract. So they don't get the 24, they don't get the 12. Okay, they get the balance. So for example, again, that situation which I used, if a person is on a fixed term for 12 months, you terminate them in the 9th month. Let's say they committed misconduct. Okay, if they sue you for unfair dismissal, the remedy in the industrial court is only 3 months, because it's the balance contract term that they have. They don't get 24 or 12. Okay, so the legal impact comes into play when you have a very specific situation where sometimes a probationer is not confirmed or dismissed, and the balance available on their contract is less than 12 months. So what will happen? Does the probationer get 12 months? Because under the IRA second schedule, they can get 12 months, up to a maximum of 12 months, or should we follow the fixed term contract rule, which is just the balance? So look at this example here on the screen. Okay, let's imagine this situation where we have a fixed term contract for 1 year, which is 12 months. And let's say that the contract provides for a 6-month probation period. Okay, so if you look at this flow chart, let's imagine what happens here. Okay, there's a 6-month probation period. Let's say at the end of the 6 months, this guy is not doing so well, and then the company says, I'm going to extend it for 1 more month to assess you. And so it brings the probation period to 7 months. And on the 7th month, they say, sorry, not working out, I'm not confirming you. And the employee says this is unfair dismissal, I'm going to sue you. So what is the period that he can claim? Okay. If you look at this, there is a 6-month probation, extension for 1 month. Balance is 5 months. The total period is 1 year. Okay. So the question that will be asked is whether the probationer, if they win in the claim, would they be entitled to 5 months, which is the balance of the fixed term contract, or should they be entitled to a maximum of 12 under the second schedule of the IRA? Okay, so there's a case which decides this point. Malayan Banking Berhad. In this case, there's a quotation here which you can read later when we circulate the slides, but essentially what the court said was just because the employee is a probationer on a fixed term contract doesn't change the nature of her contract, which is that it is fixed term for a certain duration. So they said that even if the probationer was confirmed, they would still come to an end of their contract 5 months later. And there was no guarantee that the contract would be renewed or extended. So in that situation, even if the probationer was unfairly dismissed, she should only be entitled to the balance of the contract available, which is the 5 months. Because any other construction or any other way of interpreting this would render the purpose of a fixed term contract meaningless. So in this case, the High Court held that she should only get that maximum of 5, not 12. Okay, so the takeaway from here is that actually, when you have a fixed term contract, putting employees on probation may actually limit your risk as well if it comes to a non-confirmation, because their remedy, especially if your fixed term contract is 1 year or less, the remedy will be kept at the balance expiry period. Okay, if your fixed term contract has a longer period, then of course the remedies may change, or the calculation may change. But if you have a 1 year contract, putting employees on the probation period is actually a good risk mitigation factor for you to consider. For probationers, does it matter whether the employee is in a senior position? In this case, there is some distinction between senior employees and junior employees, because there is a general understanding that if you are hired into a senior position, for example, a high-ranking position, it is usually because you would have the experience needed. And the court does not expect someone who has been working for many years, even if they are under probation, to require a lot of hand-holding and guidance. So I would say that it does make a difference whether the role is for a senior position or a junior position, because it will affect how much leeway the court gives you in terms of assessing their performance and giving them warnings. So if you can look at this case here, in this case, it was an employee who was hired for a new role as a trainer of a company. He was under probation, okay, but previously, before he was hired as an employee, he actually worked freelance for them. So not under contract of service, but contract for service, where he conducted classes and all that, and they decided, okay, I'm going to offer him a role as an employee to do this training full time. And under cross-examination, this claimant revealed that he has more than 18 years experience in this IT field, and that's why he's a trainer. And it was in fact why the company decided to offer him that role, because he had all these years of experience. So the court held here that under those circumstances, the claimant should not need to be treated or trained like a very junior employee. The claimant was hired based on his 18 years of experience. He cannot be considered someone who doesn't know what the job entails. Even if he did not need to be counseled or warned like a young probationer, the company still took steps to warn him of the shortcomings. So what the court is essentially saying is that, look, if you have many years of experience, you're hired into a senior role, you can't come in and say that, oh, the company needs to tell me what to do. I don't know what is poor performance. I don't know what are my goals. I don't know what is my KPI. So the court here gave, I would say, a higher standard on the employee simply because of their years of experience. So this would be a relevant consideration as well when you are putting high-ranking employees on probation. Let's say like a finance manager, the expectations, or the head of finance, the expectations for these people would be a lot higher than, if I'm hiring an admin clerk, and she just fresh out of college. During the probation period, maybe I need to give more guidance, I need to give more counseling, because it's maybe their first job. So they need to know a bit more about what it entails. But someone who's hired, let's say, chief of finance, head of HR, they should roughly know the basics already, and they don't need to be counseled as much. So that is the main difference when it comes to senior and junior employees. Now, I'll head into the case studies. I've chosen 3 recent cases from the industrial court in 2021 that involve probationers, and we'll see how the court treated these probationers when they were not confirmed. So the first case is Suhaila Kentong against Alice Smith School. So this is a person who was hired by a school, a private school. She was employed on a fixed term contract, and she was doing compensation and benefits, so like a HR role, okay? And she was part of the senior management group and had many years of working experience. So this was kind of like what I mentioned in that earlier case, where you are hired into a senior role, it's on a fixed term, and you are hired because you have the experience and you are suitable to carry out those functions as a compensation and benefits manager. Under this contract, she had a 6-month probation, and the company did say that we have a right to extend the probation. So after 6 months, they discovered that performance was not great. I think in this case particularly, there were issues about her attitude and her attendance. Okay, like she would often go on emergency leave, seem to be taking a high number of medical leave and annual leave, and her attendance wasn't great. So they extended the probation for 1 month. And after the extension, she was not confirmed naturally, okay, due to unsatisfactory performance. Here, the court upheld the dismissal and said that it's actually fine to not confirm her. Number one, this is because the employer had already told her many times through appraisals during the probationary period that she had some shortcomings. Okay, those were the issues. So this is what I mentioned earlier as well, that if you have a probation period, don't wait until the end. Do the appraisals or the performance monitoring throughout that. So in this case, there was consistent communication with the claimant that she wasn't doing well, and there was proof of that. So this helped the company's case a lot. Secondly, the court also said that since her role was for being an experienced and senior manager, she should have been able to work or get to work immediately without much guidance, or doesn't need to be warned like a junior employee. So she shouldn't expect hand-holding and detailed supervision. She should be independent. And the court even said that she should just, get down to work. Once you're hired, get down to it, acclimatize yourself to the job and the role and the company as soon as possible. You don't have the same kind of excuses that a junior fresh grad can give. So ultimately, the court said that the employer has a right to evaluate the probationer's attitude. Attitude is like your character. Aptitude, which is your skills. Work ethics, which is, are you a trustworthy person with integrity? And attendance. So all these factors can be evaluated. So it doesn't mean that, if you're a great employee, but you have a poor attitude, you must be confirmed. So the company can evaluate things like your attitude and even your ethics, your work ethics. Are you a hardworking person? Are you someone with integrity? So all that can be considered because the company is looking for someone to confirm and to be almost permanent part of their workforce. So they do have a right to evaluate that from their probationers. The second case that I'll go through is this Ahmad Ziali against Kasal Gome, Sendirian Berhad. In this case, the employer was a restaurant, and the employee or probationer in question was hired as a head chef at the restaurant. So he was on probation period for 3 months. After 3 months, they extended it for another 3 months because he wasn't doing well. So about 1 month before the end of the extension, so this will be in the 5th month, they told him, you are going to be dismissed, we're not confirming you. And the reason that they gave was like multitude of reasons the company gave in court. They said that he left the WhatsApp group, the company WhatsApp group, without permission. He always causes miscommunications in the company. He was attending job interviews at another restaurant instead of working. He's been spotted playing games on his mobile phone. And the quality of food which he served to the customers isn't good, substandard. All right, so the company said he's not suitable to be confirmed and we don't want him as a head chef. But in this case, ultimately, the court said that the dismissal was not fair, or the non-confirmation was not fair. So why did they say that? First of all, in this case, the company could not prove any of the charges or grounds of termination against the claimant. You have to remember that when you're in the industrial court and if there is an unfair dismissal claim, the burden of proof is on the company when there is a direct dismissal. It means that the company must prove that the dismissal is fair, not that the employee must prove the dismissal is unfair. All right, so you as an employer have the burden from the get-go, especially when you are not confirming a probationer. So you must show to the court what is the evidence you have to justify the non-confirmation. In this case, they could not establish like all those things, like what I mentioned earlier. If you look at the last slide, they didn't have proof about playing games on the phone, no proof that he attended job interviews and etc. Okay, so evidence is very important. Secondly, there was no warning or show cause letter issued to the claimant prior to dismissal. So throughout that 5 months, no formal notification that there were problems. So if there's a misconduct issue, then one would expect that it would have been brought to the attention of the claimant, either through a show cause or through a warning to say, look, what you've been doing is not good. You've been spotted playing on your handphone, please stop it. So there was again no such warning, no such show cause letter. All these issues only came up when they had to go to trial. Okay, and there was no other evidence adduced to show whether his performance improved or deteriorated during the extension period, because it was extended once. So there was some evidence that they weren't that happy during the first 3 months. But what happened in the next 2 months that led them to want to terminate him early? There was no evidence to show whether his performance improved or not. And the court said the company should have assessed him via counseling and appraisals before dismissing him. So you'll see a common theme here. I think I've mentioned it in already 3 cases, that the court is of the view that during the probation, you must counsel and you must appraise the person. You can't just, at the end of the period, say, get out. Okay, you must have an ongoing assessment of this person and counsel them if there are problems and appraise them and let them know what is wrong. Okay, in this case, it wasn't done, so it worked against the company. And lastly, even though the court took into account the claimant's behavior, the court said that, yeah, okay, maybe he's not the perfect employee. There are evidence that maybe he's not doing the best and he's not perfect, but they felt that it was not severe enough to warrant a dismissal. So the issues that were established wasn't serious enough. So in this case, the employee was found to be unfairly dismissed and the company had to pay compensation. All right, so that's the second case. And the last case for 2021, which I want to highlight, involving probationers, is the case of Daddy Ajis against MHG Desaru Hotel. So the employer was a hotel, and the claimant was a restaurant manager in that hotel. And under his contract, he was put on a 6-month probation period. Now, during the probation period, after he had already joined, the company carried out a vetting process and somehow discovered that the claimant was on the police wanted list. Okay, so I also don't know how to get this list, but somehow the company found out there's a wanted list and the claimant was on it. So what the company did was they asked the claimant, can you please clarify what is this, what's happening, why are you wanted by the police? And the claimant said that he was wanted because there was some scam case relating to his bank account. Okay, so his roundabout way of saying that he's not the perpetrator, but he is kind of like was a victim or a witness to some scam case. So that's why he's on that list. And in this company's job application, when you apply for a job, they actually do ask you to disclose whether you have been involved in or convicted of any crimes. And in this case, the claimant, when he applied for the job, he said no. Okay, he said, I'm not involved in any crime and I've not been convicted of any crime. So because of these factors, the company said, I'm going to place you on suspension and you please go and solve this problem, like resolve this issue. I don't know how you're going to resolve it, but please sort it out, because as it stands, you're on the police list and you told us that you weren't involved in any crime when you applied for this job. So I'm going to suspend you while you sort it out. During the suspension, this guy was eventually arrested by the police. And the company decided, I think that's enough is enough. You're a probationer, you are involved in all these problems, you even got arrested. I'm going to dismiss you. And all in all, the period of time that he worked with the company was only 1 month, and probably half of it he was already on suspension. So the company said, like, basically no point I go and like try to give you so many chances and let you serve out the full 6 months when right now you're involved in some dubious activity. So naturally, the claimant claimed unfair dismissal and said that, it wasn't right that they terminated him after 1 month and, terminated him just for being arrested, because arrest doesn't mean convicted. I think, as you all know, just because someone is arrested also doesn't mean that they've committed a crime. It could be a situation where they get acquitted or no charges will be pressed. And they said that essentially it's not fair to terminate so quickly like that. The company, on the other hand, said that they had a right to terminate him because, and I think number one is a breach of the code of ethics or the code of conduct in the company, their policy, because he lied to them by saying he was not involved in any crime when he made a positive assertion that I'm not involved in a crime when he did the job application. So he said that it's like an ethics issue. You have misled the company, and it's damaging for the company's reputation if its employees are involved in crime. So they said all these situations are just very bad for our reputation. We don't want to be involved and we have a right to dismiss you. So ultimately, the court said that it was fair for the company to dismiss this guy or not confirm him, even though it's only after 1 month. However, the court said that the company couldn't prove that the claimant was aware of this case at the time he declared no in the form. So the court said this part you couldn't prove, okay, because you can't show to me that he actively lied or misled you, because we don't know whether he even knew he was under investigation when he applied for this job. So they said there's no breach of that code of conduct, but the court said it is still fair to dismiss because these are the reasons. Okay, the company did give him time to resolve the issue, by suspending him and asking him to sort it out with the police, but the claimant didn't do so. However, the court felt that the fact that the claimant was arrested actually shows that he wasn't being very truthful to the company when he said he was just involved as a witness or his account was scammed, okay, because in a typical situation, the police won't arrest the victim, okay, or the witness. So the court said that is also an indication he wasn't being very truthful. And the court felt that the company was acting in good faith, but really had no choice to dismiss him, because by the time all this happened, they discovered his claim. They had to put it on suspension, and during suspension, he got arrested also. They would have lost trust and confidence in the claimant. So as he is a probationer, the company has a right to assess him, not just on performance. So not whether you just do a good job, you can carry out your functions, but whether are you trustworthy? Can the company rely on you? And in this case, the company couldn't. So the court was of the view that being involved in a criminal case, whether you declare it upfront or not, could affect the company's assessment of him as an employee, as the company does have a right not to want to confirm employees who are involved in crime, whether they are charged or not. So because he was a probationer, the court felt that it is perfectly fine for the company to come to the conclusion that they don't want him as an employee. And so his dismissal or non-confirmation was upheld. All right. So that brings me to the end of the cases. And covers my presentation. So I think because we have 10 minutes left, I believe we can open the floor up for questions. Raja?
Okay, Mr. Donovan, we have a few questions from the chat box. Number one, can we terminate the probation staff if the staff having only tardiness problem?
Quick answer, yes. Tardiness is a reason to dismiss or not confirm an employee, not just probation. Even permanent employees can be dismissed for tardiness. But you just have to make sure, like what I mentioned during the presentation, you have the evidence to back it up. So if you have, for example, attendance records, or if the employee needs to swipe their card and there's a timing about which minute they log in and log out, that would help. You can then establish that this person has been late on multiple occasions. If you don't have that kind of system, or where you don't keep track of the employee's time that detailed, you should then have things like show cause letter, ask them to explain themselves, list down the dates and the times which you observed that they were late. So that letter as itself will actually be evidence that you have highlighted the tardiness problem to them. All right.
Okay, next questions. Do we need to issue warning letter for the probationer to back up?
Highly recommended to do so. Like I mentioned before, if you've seen the cases, a lot of the cases where they did find in favor of the employer, the court held that it was because that person was counseled and warned. So you may not need to issue a formal warning letter, like on your letterhead, but do highlight the shortcomings. You can do it through a discussion and then follow up by email and point out the things that you're concerned about. So it doesn't need to take any specific format, but do make sure that you fulfill the element that you have told this person that there are problems.
All right, next question is change of role for probationer. Is the probation period shall start over?
Okay, I think this question means that if I decide that this probationer is not good in their role, and I want to give them another role because maybe it's not working out, but there's something more suitable for them. Does the probation period start over? This is really up to you as a company. You can say that, sorry, your probationary period for this role wasn't good. I don't think you're suitable, but there's another opportunity for you. I want you to try out this role, but you are still going to be placed under probation as well for another, let's say 3 months, 6 months. So that's really up to you.
Okay, another question is, a senior permanent employee is promoted to GM. However, with the promotion, his employment status was changed from permanent to fixed term contract due to the high ranking role and put on probation as well. The employee accepted this condition. Is this practice acceptable? Will there be any legal implications?
All right. So generally, converting someone from permanent to fixed term requires consent. So if the employee has confirmed and agreed to it for whatever reason, then generally that is acceptable. As long as the usual principles apply, that he wasn't forced into it, he wasn't threatened, and he wasn't misled into this. Generally, that they will be bound by the contract, and you can change that. The real issue with this normally arises when you ask to change it and the employee says, no, I don't want to change. I want to stay on a permanent contract. They can actually raise a claim for constructive dismissal, like offering to or threatening basically to switch their role without their consent could amount to constructive dismissal. So this type of changes, you should evaluate it carefully. Simply because this scenario looks to me like it's not a favorable change from permanent to fixed term and still be on probation. I think it doesn't look favorable to the employee, so it is unlikely to be agreed to. And if the employee disagrees to it, then you may run into some legal issues. All right.
Thank you. There's another question. Can the company issue warning letter to probationer for poor performance or only for misconduct?
You can issue for poor performance as well as misconduct. So like I said, it doesn't matter how it looks like, whether you use the word warning letter or whether you use the letterhead. What is important for poor performance is that you highlight the shortcomings and what you expect to improve. For misconduct, normally the warning letter will be issued after you have already proven all those misconduct, like you do a show cause, ask your explanation, and then you decide that you're not going to dismiss, but you're going to warn. So it's a lesser form of punishment. So that's the distinction between warning and warning for poor performance and warning for misconduct.
Okay, next question is, fixed term contracts may be renewed yearly. Would you recommend a cooling period between each year? What's the implication if there is none? Is it advisable to put a cooling period? How long would you recommend the period to be?
All right. So for fixed term contracts, normally the issue becomes apparent when there's repeated renewals and there's no cooling off period. Sometimes you can risk the fixed term being converted to a permanent contract by the court if they feel that in reality this person is really a permanent employee and you are just putting a fixed term contract to kind of like limit your liability and kind of circumvent employment laws. So the court can convert it to a permanent contract, and they normally do that when there's multiple and successive renewals. So while the law doesn't say actually what is an acceptable cooling period or what's the minimum cooling period before there's a break, typically if you do want to kind of mitigate your risk in that sense, a cooling off period is recommended. Typically we would say 30 days is a good period for break. To sever that ongoing relationship. I think primarily because while the law doesn't say that specifically, the closest analogy that we have is that if you look at the termination benefits regulations, they define continuous contract of service as even aggregates of different employment periods, where the intervening period is less than 30 days between them. So just using that as an analogy, 30 days would be a good break for cooling off, but this is not like the law that is stated anywhere. So this is just something that you can consider for cooling off period, like 1 month minimum.
Okay, next question. If the company has extended the probation period several times and has been objected to disciplinary proceeding, do the HR still need the confirmation of the probationer's performance from the supervisors? And is the only way of terminating the probationers is by way of dismissal through disciplinary proceeding only?
So I think the question is asking if there's two situations, like one, the performance of the probationer is already bad and the probation was extended, and at the same time, there's some discipline problem or misconduct. So the question is, if I already am going through disciplinary proceedings, do I need to still evaluate their performance, or can I dismiss them for disciplinary issues? So again, it really depends on the situation. There is nothing stopping you from dismissing them for all these factors. You can say that I'm not confirming you because, number one, you've went through a disciplinary process and you've been found guilty of committing this misconduct. In addition to that, your probation, your performance hasn't been good during the probation period. Okay, and all the evidence that we have about that is there. So you can do a combined rationale for not confirming. Or if, let's say, the dismissal or the misconduct that he committed is so severe that you need to get rid of him immediately, then you can rely on that purely to dismiss. For example, if he go and like I said, like go and punch the supervisor in the office, something that serious, then it really you don't need to go and do an evaluation about the performance, because punching your boss is good enough to get you out of the office immediately. So you really have to weigh that, what are the severity of the offenses being committed and whether it's appropriate for you to either choose one reason if it's strong enough, or you just do a combined thing where I've evaluated you throughout your whole probation period and these are all the factors that came out.
Okay, next questions. If a monthly or bi-monthly performance review has been conducted to an employee, the performance issue and areas of improvement will be discussed during the review so that he knows his shortcomings and given chance to improve his performance and documented in the performance review form. But the company did not issue any warning letters to the employee. How would be the legal impact if the company non-confirm an employee without issuing any warning letters prior to that?
I don't see this as much of an issue. Like I mentioned earlier, there's no requirement to issue warning letter. It is a good thing if you have it because it shows. But I think in this case, the participant has stated that the performance issues and areas of improvement and all that have already been documented in the performance review form. It's just that they didn't have a formal warning letter to say that your performance is poor. So I feel that in this case, the performance review form and the documentation should be sufficient to establish that there were performance issues.
Okay, another question is it valid for us to terminate a probationer if we only communicate with the probationers and giving them warning letter without coaching them or advise them to attend any related training?
So this will depend really on the nature of the poor performance. So if it is a performance issue that really can only be addressed through training, then the company has to act reasonably. So if you're requiring an employee to do certain work that requires a certain skill set that needs training, then of course it may not be reasonable to terminate them without sending them for the training and blaming them for not knowing how to do it. So that could be one angle. If it's, like I mentioned, like a senior employee in the slides that I've shown, they should know the basics. So if it's like a finance person, head of finance, they can't come and tell you that, oh, sorry, I needed training on how to balance a book. I need training on how to read a financial report. You need to have coached me. I don't think that would be an acceptable answer as well. So we really need to see the nature of the employee's role, the employee themselves, and what type of job functions you are expecting them to do before we can assess whether you should complement the performance review with coaching or training, and what kind of training.
Okay, last question, Donovan. How many times can we extend the probation?
This was covered in my slides. No maximum, no minimum number of period you can extend as the circumstances see fit. But again, you are guided by reasonableness as an employer, because under employment law here, we go by equity and good conscience. So while there's no fixed time period or fixed number of renewals, you have to act reasonably. If you are renewing someone's probation, let's say for 10 times, every time is 3 months, 30 months of extension, I think it's unreasonable, and there will be a question, I think naturally, by the court, how come you cannot assess this person well enough after a few rounds, and why does it take you 30 months? So it could be seen as like a sort of like victimization or bad faith exercise. So normally I would say that very rarely I've seen extensions of probation exceed 2 times. That's just in practice. Because by the second time, if you really want to extend a third time, you would just decide not to confirm this person. Because why would you want to extend and deal with a person who is not good enough to be confirmed after 2 times? So in practice, we don't really see multiple extensions.
Okay, any more questions? I believe there's no more questions. For the participants, we appreciate if you can let us know your feedback by answering the poll questions in front of you right now. Thank you.
So thank you very much, Mr. Donovan, for this very insightful and meaningful discussion on the topic probationers. Very interesting indeed. And thank you, ladies and gentlemen, for your questions. And I've seen that it has been adequately replied. Thank you for attending our today's webinar session, and we hope to see you again in our future sessions. For now, goodbye from IR Law. Thank you very much.
Thank you. Bye.
Bye.
Thank you.
Thank you.
Thank you. Bye-bye.
Thank you.
Thank you.